Okay, here's your paperwork. You can have the yellow X.
Okay.
Package.
Okay.
This is the state of Wisconsin versus KEJA Schreiber, 25 CF 2969. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
KEJA Schreiber appears in person in custody and alongside attorney Connor Sheehan. I can confirm she is eligible for representation through the Office of the State Public Defender. Her address is correct on the complaint. We'll waive its reading. And there is a probation hold in place. I believe that's all I have.
All right. You have the right to have an attorney represent you throughout this process. Looks like you are eligible. I find probable cause in the complaint. What are the state's recommendations?
Thank you. The state is seeking cash bail in the amount of $5,000 in this case with conditions that the defendant not use or possess any dangerous weapons as defined by the Wisconsin statutes, that she have no contact with Momodu, Momodu, last initial D, or Abdu, Abdou, also last initial D, no contact with any of the co-defendants, and that she be placed on pretrial services with GPS monitoring if she's able to post. In support of this recommendation, I'll highlight for the court that the defendant is currently on DHS supervision for an NGI related incident. It's indicated here that, of course, she has co-defendants where some of the fault is placed on them, but this was an extremely dangerous event, and the evidence that the state has at this point early on in the process is that she likely set up the incident that took place. So I think all that supports the state's recommendation. I'll ask that you adopt it in full.
All right, and who is the second no contact?
Abdu, Abdou, last initial D.
Right. And response.
One moment, please. Your Honor, I have to raise competency.
All right, we'll address bail first. Do you have a position on bail?
Your Honor, I have no basis to object to the non-monetary conditions. I would object to the cash bail based on her eligibility for state public defender representation and the indigency that it implies. And that's all I have to ask.
And can you pull the microphone just a little bit
Sure.
closer, please? Thank you. Any response from the state?
No, thank you.
Right. I agree with the state. I think their recommendation is a little bit, quite a bit on the low end from what I was expecting. That being said, it does look like Ms. Schreiber is by far the least culpable of the co-actors, co-defendants. So I'll order $5,000 cash. The condition that she not use or possess any dangerous weapons, as that term is defined by statute. I'll order the no contacts with Momodu B and Abdu D. I apologize for mispronouncing those names.
Sorry, the last initial for Momodu is also D.
Okay, I'll make that correction. I'll order no contact with any co-defendants. I'm not going to order pretrial services. I'm not going to put it on just to watch where she is, especially if there's another agency supervising her. Competency has been raised. Any objection from the state or any position on me ordering an outpatient evaluation?
No.
Okay, then I'll order the outpatient competency evaluation. We won't set this for anything further pending the outcome of that evaluation. Anything else on behalf of Ms. Schreiber?
No, Your Honor.
Okay, very good then, and we are adjourned. Thank you.
This way. Next up is Kelly Vitens for bail on hearing.
Afternoon.
Hey. Yeah. What, someone else?
I'm sorry. This is a bail one here.
Bail?
It's a group file, I see.
Okay.
One of them. This is the group file of bail hearing for Kelly Vitens, 25 GF 37081. Do you need a moment?
Yes.
Okay, then we'll hold off on appearances for a second.
Thank you.
All right, can I have appearances, please?
ADA Cecilia DeMarco for the state.
Kelly Vitens appears in person in custody by attorney Connor Sheehan. The address I have is 2812 Lakewood Circle in Stoughton. That is correct. She is eligible for representation through the Office of the State Public Defender.
So you have the right to have an attorney represent you on a case like this. There hasn't been anything filed yet. But we'll get to that as we come up to it, okay? I know this is you look distressed, so just take a deep breath, okay? Everything will be all right. You've got your attorney to represent you. On behalf of the state.
Thank you. So as far as the charging decision goes, we're asking for an order and date in about 30 days. There's more investigation that needs to be done in order to determine an appropriate charging decision here. So we're asking today at the bail hearing that the court set a signature bond with the condition that the defendant have no unsupervised contact with any children.
I'll take your response when you're ready.
Thank you.
Like kids. Oh, they were. Terrible.
Your Honor, based on the fact that it hasn't even been charged yet, I don't see the necessity of the no unsupervised contact. It's my understanding that they're above the age for a car seat, so it wouldn't be a matter of whether or not they
Can you
were,
speak up just a little bit?
pardon me. We don't see the understanding, or pardon me, we don't understand the necessity of the no unsupervised contact. If it were a no driving with children, perhaps that would be understandable, but it's my understanding that the children were above the age where they would be in a car seat, so that wouldn't be an issue if they weren't properly secured. It hasn't been charged yet. There hasn't been probable cause established that she has put any children at risk, so she lives with her children, they're her kids. I don't see the need for that.
All right. And response from the state.
So based on the information the state has, we do believe this is absolutely necessary to protect the public and specifically the children from the defendant's actions. It's our understanding that one of the children contacted one of their half siblings who called police on their behalf. The children were found shaking and crying. And once they got out of the car and made contact with law enforcement, they reported that the defendant was driving fast and making statements indicating she intended to kill both herself and them. She was driving recklessly with the children who were not secured. They were not found to be, or not reported to have been wearing seatbelts at the time. I don't think this is a situation where cash bail is necessary, especially since the complaint hasn't been filed. I understand that, but based on the information that we have, all signs point to the fact that these children are in danger. So that is why we're asking for no unsupervised contact. We're not asking for no contact as a blanket condition, but we do believe it needs to be supervised given the concerns that we've raised.
And that's with any child?
Correct.
So how, do we have any information about how the vehicle was stopped?
I believe the defendant pulled into the residence of her parents, the children's grandparents at one point, and that's where law enforcement met them. It looks like CPS has been involved. There's a screening decision that is still yet to have been determined. There have been previous contacts with the agency in the past.
Do we know when those contacts were?
Looks like more than 10 reports have been made since 2017.
Your Honor, just quickly, have any of those contacts manifested in CHIPS orders? Because I don't believe they have.
I don't see any. There's a number of, when I put in Ms. Vitense's name into our system, there's a number of things that pop up. A small claims case from 2024, one from 2021. Some traffic tickets in 2020. I don't see anything that would indicate, just from the case title, or the
Sure.
case number, that a CHIPS petition or anything like that was filed. That doesn't mean investigations weren't done and weren't substantiated or anything like that. But I think there is some weight to that. All right. So I'm going to order a signature bond with the condition, Ms. Vitense, that you comply with any CPS orders that are put into place. So if CPS says you cannot have contact with your children, you cannot have contact with your children. If CPS says you can have supervised contact, then you can have supervised contact. Or if they put restrictions on that, you gotta comply with their order, okay? I think they'll be the agency with the eyes most closely on this case. I'm also going to order that you cooperate with any appointments or anything like that that they set up for you, okay? So if the social worker wants to meet with you, make sure you meet with the social worker. Find a way to make that happen, okay? If you have COVID and you can only meet by Zoom, say, hey, I can't meet in person, but I can meet by Zoom, okay? This is a bail condition, so it could get escalated if there's violations. It might be that the state chooses not to file anything and it goes away. So you're gonna have to play your part in this process and show up when you need to, okay? And
The state said about a month for the complaint. I'm looking at February 2nd at 8:30 right now for the.
That's the parents, okay.
I'm considering whether an additional order about driving with your kids would be appropriate. Part of every condition of bail is that you follow the law. So if you sign your signature bond, you're agreeing to also follow the law. So make sure your kids are secured appropriately. Because if the state does charge something out and you violate your bail, then you can get charged with bail jumping, okay? And actually, I think.
If I drive,
No. If you have a kid, if you're driving with the kids in an unsafe situation.
Oh,
Okay.
okay.
And because this was referred up as I believe, a second degree recklessly endangering safety, it could be charged out as a felony bail jumping, okay?
Okay.
So please make sure you're following this order. This is your chance now. It's not, coming back to court saying, can I have a second chance? This is a chance, okay? All right.
No problem.
Is there anything else I can do for the parties today?
No, thank you.
Thank you.
That's all. Thank you.
Next up is JANAUHA Johnson for forfeiture.
This is Dane County versus JANAUHA Johnson, 25 FO 2556. Can I have appearances, please?
ADA Cecilia DeMarco for the state. The defendant appears in person in custody without counsel.
All right, so we're here because the state has decided to charge your case as an ordinance violation instead of as a criminal violation. I expect there will be an offer to resolve your case today. Just so you're aware, the charge is a county disorderly conduct. What that means is whether you decide to resolve your case today or not, you'll be unconditionally released from custody for this case. However, if you have other cases, they could affect your release. Is there an offer to resolve today?
Yes, the county is offering to resolve for costs only.
So you have an absolute right to plead not guilty, and we can set this case for further proceedings.
Yes.
Otherwise, you can enter a no contest or guilty plea, and you'd be fined $114.50. Payment of that amount can be arranged through the clerk of courts, and you'd have 60 days to pay. Would you like to resolve today for that amount?
No, I do want to plead not guilty because I didn't touch her.
Then I'll enter a not guilty plea on your behalf.
Thank you.
This will get set for a pretrial conference. What you should know is the trial for this case will be to a judge unless the court receives within 10 days of today's hearing
Okay.
written notice of a request for a jury trial and a $36 non-refundable fee.
Okay.
That's a 6-person jury. You don't have a right to an attorney in a case like this, but if you'd like one, you can hire one at cost to yourself. And assuming nothing new comes in, I'm guessing the state will likely keep this offer open until the pretrial conference, okay?
Amazing.
Do you have any questions for me?
Will I be getting released?
Yep.
So right now,
regardless of
we're
what you did today, you'd be released. We don't incarcerate people for tickets.
okay. Awesome. So about what not trying to be too particular about what time can I give my to let my children know?
I'm not sure. That'll be up to the jail and the processing.
That's
but I'm
fine.
sure they'll get you out of here as soon as they can.
Alrighty, I appreciate it. Thank you.
Yep, thank you.
Next up is Ryan Spence appearing by Zoom.
And do we have Mr. Spence?
Yeah, I'm here.
All right, good afternoon. This is the state of Wisconsin versus Ryan Spence, 25 CM 3064. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
Ryan Spence appears remotely over Zoom and by attorney Connor Sheehan. Mr. Spence, I've spoken to your attorney, Joe Ventola. Can you hear me?
Yeah, these are misdemeanor charges. He
Okay,
says,
one second, Mr. I'm going to ask you not to speak. Everything you say can be used against you going forward, okay? So I'm going to ask you a few questions, and we'll get through this, all right?
no,
so,
the judge just says.
Have you received a copy of the complaint in this case?
Yeah, it's all misdemeanor.
Okay, yeah, that is correct. So on here, it has the Beacon as your address. Is that where you'd like your mail to go?
Yes, sir.
Okay, great. We'll waive the complaints reading. The address is correct. He currently has representation through my office, so that's been settled.
All right. And just so you're aware, sir, you have the right to have an attorney represent you on cases like this. Sounds like you've got an attorney. I find probable cause in the complaint. What are the state's recommendations?
Thank you. The state is asking that you set cash bail at $400 with conditions that the defendant refrain from using or possessing any alcohol and that he be placed on pretrial services to monitor any alcohol use. In support of this recommendation, I do want the court to draw attention to the fact that the defendant has posted cash bail in previous cases. He posted $150 in 25 CM 2182. It looks like that was an initial amount perhaps as it was refunded a couple months later. Nevertheless, he also posted $200 in 25 CM 2458. That was back in October of this year. He's received various signature bonds since then and continues to pick up cases. This is the defendant's now fifth pending case, fifth pending case, counting the present matter, all of which, to my knowledge, involve alcohol. So the fact that he has posted cash bail in cases with very similar factual scenarios does not bode well. He continues not to follow court orders. I think that $400 with pretrial services to monitor his alcohol issues is appropriate.
All right. And response?
Thank you, Your Honor. He has posted cash in the past, but the most recent posting was $200 in October, as the state said. Yes, he has open cases for similar patterns regarding alcohol, but does not indicate an ability to pay going forward, nor does it speak to the severity of the charges. Mr. Spence has open cases. He also has no convictions since 2018. None of these offenses are Act 3 eligible. I don't believe they speak to his inability to return to court, which is really the core issue. This is a man with a drinking problem. It's not a man who has shown an inability to return to court. It's not a man who has demonstrated an ability to afford cash bail. So I'd ask the court to order a signature bond.
Right. And any response from the state?
I think that an increase that doubles the amount that he previously posted is appropriate under these circumstances. He is charged with obstructing or resisting an officer here, which does not bode extremely well for indications of compliance with future court orders, and court orders do include making all court dates. I also see a conviction from Dodge County for the same charge I just cited, obstructing or resisting an officer. He was convicted in December of 2018 in Dodge case number 18 CM 239.
If I may,
Yes.
the fight or flight impulse when intoxicated, whether or not to comply with officers, is fundamentally different than the premeditated decision to either return or not return for one's court date. So I dispute the equation of the two.
All right. But part of the problem is that the bond conditions ordered that Mr. Spence not consume alcohol. Voluntary intoxication is not a defense at trial, but part of the reasons we put bond conditions in place are to help support and encourage people to avoid things that may lead them to pick up charges and to protect the public from certain types of behavior. In this case, I do believe $400 cash is a reasonable amount. It is an escalation. Mr. Spence's exposure is increasing. And I think you're right there. From what I can tell, alcohol does seem to be an issue for Mr. Spence. So I'm going to encourage him to, work on that issue. That's not something I'm going to order in terms of treatment. But what I will
I need
order
to
is.
say something, sir. I need to say
Okay.
something, sir.
So, sir, anything you say could be used against you.
That's
You're
fine,
attorney-
that's fine, that's fine. I have a brain injury, sir. I'm being
Right.
in a maximum secured, this is a maximum secured.
Ryan, Attorney Ventolo has specifically asked me to ask you not to contribute. We're aware, okay? We know.
So that may be an issue for a future court date, and bail can be modified. I'm going to order pretrial services, and that Mr. Spence is only to be released when they're open so that he can immediately report. And I'm also, if I failed to say it, I'm going to order that he not use or possess any alcohol. That condition aligns with other conditions in the other cases he has open. I'll enter not guilty pleas on Mr. Spence's behalf. Believe that's all I can do for the parties today, so we are adjourned. Thank you, sir. I wish you the best.
Next up is AMANCIO, BERECHE, MENDEZ.
Necesitamos una interpretación. Ahora va a escuchar.
This is the state of Wisconsin versus Amancio Josue Bereche Mendez, 25 CF 2977.
Este caso es el caso del estado de Wisconsin contra Amancio Josué Breche Méndez, 25 CF 2977.
Ms. Filipiak, have you been sworn in today?
I have not. La
Okay.
intérprete no ha prestado juramento hasta el momento.
You swear or affirm that your interpretation today will be fair, accurate, impartial, and comply with the standards set for interpretation by the Wisconsin Supreme Court?
I do.
Very good. Can I have appearances, please?
Preséntense los que compadecen.
ADA Cecilia DeMarco for the state.
Cecilia de Marco es la fiscal para el estado.
Amancio Bereche Mendez appears in person and alongside attorney Connor Sheehan.
El señor Amancio Bereche Méndez está presente en persona, representado por el licenciado Sheehan.
The address is correct.
La dirección es la correcta.
We've received a copy of the complaint and will waive its reading.
Hemos recibido una copia de la demanda judicial y renunciamos a una lectura formal.
I'm not sure whether he's eligible for representation through the Office of the State Public Defender.
Y no hemos determinado si él va a calificar para los servicios de la Oficina del Defensor Público.
So you should reach out to the state public defender to determine if you're eligible for representation through their office.
Usted debe ponerse en contacto con la Oficina del Defensor Público para ver si usted califica para
Yep.
que le designe un abogado.
They have a long wait list, so you'll want to do that as soon as possible, so you don't fall down that list, so other people don't jump ahead of you. Okay?
Tienen una lista de espera bastante larga, así que debe de contactarse con ellos lo antes posible para que usted no pierda tiempo esperando.
I find probable cause in the complaint.
Determino que hay pruebas suficientes en la demanda.
Is there somebody who identifies as a victim in this case who would like to make a statement? If so, please unmute and identify yourself.
¿Hay alguien aquí presente que se identifica como un víctima en este caso? Si es así, ¿puede activar su micrófono e identificarse, por favor?
Aló, buenas tardes.
Sí.
Buenas
Good
tardes.
afternoon. Hello.
Soy el padre de Amancio.
I'm-
Estoy un poco confundido porque se llamó al 911 para que mi hijo sea atendido en la clínica donde él era paciente por sus intentos de suicidio. Sin embargo, él cuando vio a la policía se alteró y se ocasionó todo esto. Y él, en vez de ser llevado al hospital, donde se llevó en primera instancia por 3 horas, fue llevado al detenido. Solo tuvo 3, 4 horas en el hospital, después fue detenido y es donde él completamente se alteró y perdió el juicio. Ella se sentía mal porque él ha tenido 3 intentos de suicidio. Están en su expediente clínico.
¿Me permite
Y yo-
un momentito? Permita la intérprete un momentito, señor. Ahora usted sigue. I am Amancio's dad, and I'm not sure what happened. 911 was called because of
Sí, que se
him
vaya
wanting
nomás.
to commit suicide. When he saw the police, then he found out the call was made.
Ahí
And they took him, they
hablamos
detained
después.
him, and they
Ahí, mijo.
took him to the hospital where he was for about 3 or 4 hours. And he felt really
Estoy con
bad
una-
about this since
con una
this had
videollamada.
something to do more with him wanting to commit suicide.
All right. Thank you for that information. Is there anything else you'd like me to know?
Muy bien, gracias por explicarme eso. ¿Y hay algo más que usted necesita decirme?
Quisiera pedirles, por favor, que mi hijo siga con su tratamiento clínico. Yo me comprometo como padre a llevarlo y hacer seguimiento a todas sus cosas, porque es un joven que desde su infancia sufrió mucho maltrato de su madre. Y toda esa historia clínica la tengo yo del país donde él nació. Yo lo tengo desde los 8 años de edad lo tengo bajo mi custodia.
Permítame un momentito, señor. Okay, I would just like to ask, please, that you let him get out so he can continue his clinical treatment. I will be responsible to take him to all of his treatments. He is a very young man and he has suffered very much since he was young.
Una última palabra. Él nunca en los 10 años que vive conmigo, nunca mostró ser violento. Él se asustó cuando vio a las policías y lo quisieron detener. Su acción de que estaba con sobredosis de pastillas y la mezcla de alcohol fue la actitud que él tomó y que me imagino que se debe estar arrepintiendo de haberle faltado a la policía. Yo como padre me siento mal por las acciones de mi hijo y pido por favor que este mal momento que tiene mi hijo lo podamos ayudar entre todos. Él tiene mucho sufrimiento desde su infancia y yo siempre trato de apoyarlo, de estar con él. Un buen empleado.
Permítame un momentito, señor.
Yeah.
The interpreter can't understand everything because of the emotional state, but the interpreter knows that he said, you know, he's, when the police came, he got afraid. He's not a person that has committed any kind of crimes or anything, but he was under the effect of pills and alcohol. And I imagine he's really sorry for having responded that way to the police. And me as his father, I feel very bad for his poor behavior.
All right. Thank you, sir.
Gracias, señor.
What's the state's position?
¿Qué opina el Estado?
Thank you. The state believes a signature bond is appropriate under the circumstances, particularly due to the defendant's age and lack of criminal history.
Yo creo que está bien una fianza bajo firma, dadas las circunstancias, la edad de este joven y su falta de historial penal.
The state is recommending that the court set a condition of no acts or threats of violence towards Sergio B.L.
Y el Estado está pidiendo que su señoría imponga la condición de que él no haga ningún acto ni amenaza de violencia en contra de Sergio B.L.
To be clear, we're not asking for no contact with his father.
Y en específico no estamos pidiendo que no tenga ningún contacto con su papá.
We are asking that he have no contact with law enforcement officers Kyle Casasola, C-A-S-A-S-O-L-A.
En particular, estamos pidiendo que no tenga ningún contacto con el oficial de policía Kyle Casasolas, C-A-S-A-S-O-L-A.
As well as Officer Miguel Baldovino, B-A-L-D-O-V-I-N-O.
Y también que no tenga ningún contacto con el oficial Miguel Baldovino, B-A-L-D-O-V-I-N-O.
Unless necessary in their official duties as law enforcement.
A no ser que sea necesario en sus responsabilidades oficiales como oficiales de policía.
Thank you.
Gracias.
Thank you. No objections.
No hay objeción.
Very good.
Muy bien.
I'll enter a not guilty plea to count 2.
Voy a sentar una declaración de no culpable a cargo número 2.
I'll order a signature bond.
Voy a ordenar que él firme su fianza.
I'll order that you make no acts or threats of violence to Sergio B.L. or yourself.
Y en libertad voy a poner la condición que usted no haga ningún acto ni amenaza de violencia en contra de Sergio B.L. y ni en contra de sí mismo.
Do you understand that?
¿Entiende esto, señor? Yes.
Do you understand why I'm ordering that?
¿Y usted entiende por qué lo estoy ordenando? Yes, I understand why.
Okay, we want you here.
Queremos que esté aquí.
Your dad wants you here.
Su papá quiere que usted esté aquí.
So we need you to stick around, all right?
Necesitamos que permanezca aquí con nosotros. ¿Entiende?
You've got an important
Okay.
story to tell.
Usted tiene una historia muy importante.
I'm going to order that you have no contact with Kyle Casasola. Or,
Yes. Mhm.
Officer Baldovino, except in their official capacity as law enforcement.
Es mi orden que usted no tenga ningún contacto con el oficial Casasola ni con el oficial Baldovino, a no ser que sea necesario en su capacidad oficial como policía.
Count 1 is a felony. Will the time limits be kept for the prelim?
Cargo número 1 es un delito grave. Vamos a mantener los límites de tiempo para la audiencia preliminar.
We'll waive just to make sure he has time to get a lawyer.
Vamos a renunciar a los límites para que él tenga suficiente tiempo para conseguir un abogado.
We'll waive the time limits then for the preliminary hearing.
Muy bien, vamos a renunciar a los límites de tiempo para la audiencia preliminar.
We'll see you later. And we are.
Nos vemos luego y se levanta la sesión por hoy.
Next up is Dalen Pineda.
¿Ya viene a hablar inglés o quiere la grabación? Bueno, porque parece que aquí sí yo lo voy a hacer traducción.
This is the state of Wisconsin versus Darwin Pineda, 25 CM 3063. Can I have appearances, please?
Preséntense los que aparecen, por favor.
DA Cecilia DeMarco for the state.
Está Cecilia DeMarco para el Estado.
Darwin Pineda appears in person, in custody, and by attorney Connor Sheehan. He is eligible for representation through my office. And the address is correct on the complaint. We'll waive its reading.
So you're eligible for a public defender, and you have the right to have an attorney represent you on a case like this. I find probable cause in the complaint. What's the state's position?
The state recommends a signature bond in this case. As conditions, we're asking that the defendant be banned from higher ideal. It's spelled HIGHER space IDEAL. That's located at 214 State Street. Also asking that he be prohibited from using or possessing any alcohol during the pendency of this matter.
One moment, please. No objections.
All right. Then I'll order a signature bond. The conditions that you're banned from higher ideal on State Street, Madison, and that you not use or possess any alcohol. I'll enter not guilty pleas on your behalf, and we are adjourned. Thank you.
Next up is David Patton, appearing by Zoom. Thanks, David.
Thank you. She just snuck right out.
Yeah, go ahead.
I can't even see, I cannot see it clearly.
The what?
I can't hear or see it clearly.
I'm gonna fix it. Get down, you gonna go up or go down? You gonna be up or down?
I don't give nobody permission to speak for me.
This is the state of Wisconsin versus David Patton, 25 CF 2962. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
Hello? Oh, no, I give nobody permission to speak for me. I give nobody permission to speak for me. Who is this person standing on that defense? Because I've signed no papers. I've given no person permission to speak for me.
All right, you have somebody here who could represent you.
I
You
gave
can also
nobody
represent-
permission to represent me.
Sir, let's have a conversation, okay? I'm not saying somebody's going to represent you. I'm just explaining to you the situation.
I like
You
to
have
be
a-
present
you
so
have-
that I can stand
you
where
have
I
a-
am and I
sir.
can establish jurisdiction.
Sir, I'm
you
not gonna
think that I
talk
am?
over you. So what can happen is I can just mute you. Or we can have a conversation. I'm
Yes,
hoping
sir.
we can just have
I
a
would like not to be
conversation.
muted.
Okay, so you have somebody here who could represent you, a good attorney, no charge.
Why would they need to represent? Who do they think that I am?
Well, would you like to speak with the person here?
Speak to who?
Uh,
He's never been given permission to represent me or speak for me. So why is he standing in the position that I should be standing in? I never signed
Well-
any papers. I never given nobody permission to represent me. He's gonna falsely represent me, sir.
okay, well, he's not gonna represent you if you don't want him to, but.
Who does he think
why
that
don't
I
you-
am?
Why don't you have a quick talk with him and see if he can
I'm trying
change
to
your
get
mind,
into the
okay?
courtroom. Can we continue this till tomorrow so that I can be in the courtroom? They won't let me in the courtroom. I need to be in the courtroom because I need to know who do y'all think that I am.
I don't think we're running into time limits.
My name.
Pretty sure I did just mute the defendant so that we could actually have a conversation about his case. He had asked a question about sending this over to tomorrow. According to our local court rules, he is a must go today. If he's requesting to be sent over to tomorrow, we can certainly do that. I don't know that he would be able to come down here in person though. That decision is made by the bailiffs and by the jail staff due to any security issues.
All right.
So we could send it over to tomorrow, and there's a chance he could appear in person, but no guarantee.
Okay. So did you understand that, Mr. Patton? And we'll get you unmuted here. And if the bailiff could unmute?
Don't have prescription eyeglasses
you.
because they're in my
So-
property. They won't give them to me and I can barely hear
Mr.
the city. I've done
Mr.
this
Patton,
before where y'all
Mr.
rushed
Patton,
me without me. And it was. a
Mr.
fallacy.
Patton. So I don't know if you heard that, but we could set this hearing over. You are a must go for today, but that wouldn't guarantee, you would likely still. I don't choose how you appear. That's up to the bailiffs.
Listen, okay, this is what I'm saying.
Okay.
I am a free man. My name was given to me, David. I inherited a family name, Pat. That is my property given to me at birth. If you are attempting to identify me as my name, that is a fallacy of the courts.
Okay.
Listen, I am not a sovereign citizen. I stand with the Constitution of the United States. I am not here claiming to be sovereign. I am not here claiming to be any of that. I am not going to go outside of the Constitution of the United States. But what I am saying is that I should not be coerced or forced to join in any contract.
Mr. Patton, do you have a good mailing address, sir?
What do you mean? My address is my body, sir. I'm a live, living soul. My
All right.
reside in this body. You
All
look
right.
at the address. The address is
And-
the body, sir.
All right, and you have the right to have an attorney represent you in a case
I
like
don't.
this.
I
all right?
listen. I'm here. I'm
Sir,
here.
sir,
I'm
we have
appearing in
lots of-
special
sir, can
I'm
we mute him?
appearing in special cause because
So, how would the state like to proceed? Attorney Sheehan, we could have you step in as counsel. Mr. Patton appears that he might not be competent to represent himself. It's very difficult to have a conversation with him, and I'm not sure that he has necessary skills to represent himself. So I guess I'll take party's position on a representation here.
If I may, Mr. Patton has counsel through my office already, Attorney Dickey. I won't deign to speak on her or Mr. Patton's behalf if he won't have me. He has not been found legally incompetent to my understanding. If he is asking to have his hearing set over, I would defer to him.
Okay.
I've had limited interactions with Mr. Patton in the past in my professional capacity, and his expressed ideals that he shared today, those are consistent with expressions he's made in the past. I don't know that he meets the threshold yet for competency. I understand the court's hesitance here. I think we're sort of on the borderline, but I think if he's able to work with his attorney as Mr. Sheehan already indicated that he is represented. That may be something that we revisit in the future. As far as today's purposes, I'll defer to the court, given the sort of practical considerations raised by the ability to transport him here.
Very good. So, Mr. Patton, would you like Attorney Sheehan to represent you today, or would you prefer to represent yourself? And if the bailiff could unmute, I would appreciate that.
If found competent, I understand the decorum of the court, I understand exactly how it works. I'm not here to upset the court. I'm not here to work outside of the Constitution of the United States.
Very good. Would you like to represent yourself today or have Attorney Sheehan represent you?
I don't even know this person.
Would you like to represent yourself or have Attorney Sheehan represent you?
I don't even, when I'm saying this, I'm confused and I don't know who this person is. Is he a member of the Bar Association?
Yes, he's an attorney.
The Bar Association is a British accredited registry.
Okay.
He's not for America. It's a
So
British accredited
sir, can you answer my question or else I'll just have Attorney Sheehan represent you?
Listen, I would like to be represented by somebody who's an American agent.
Okay, well, that's Attorney Sheehan. We can mute Mr. Patton.
I do not wish.
Address, I find probable cause in the complaint. What are the state's recommendations for bail?
Yeah, the state is asking if the court set cash bail in the amount of $2,500. We're asking for conditions that follow. No contact, direct or indirect, with Troy, TROY, last initial P as in Philip, or Tanisha, TINESHA, last initial J as in John. That he be banned from the 1100 block of Moorland, MOORLAND Road in Madison, that he refrain from using or possessing any alcohol during the pendency of this case, and that he be prohibited from using or possessing any dangerous weapons as defined by the Wisconsin statutes. In support of this recommendation, I'll highlight for the court that this is an Act 3 eligible offense as far as the substantial battery charge goes. It's my understanding the defendant is already prohibited from having contact with the primary victim here and from being on the 1100 block of Moorland Road per the bail conditions that were previously set by the court in 25 CM 2292. The behavior here is, I would call it excessively violent, as it's alleged that the defendant essentially attacked the victim and beat him into unconsciousness. I think this supports the state's recommendation for cash bail, as well as the factors indicated specifying that he is violating specific conditions of bond that were already ordered by the court. I'll defer to defense from this point forward to make any response to the state's recommendations.
Very good.
Thank you. The allegations are obviously violent. The facts are obviously violent. That being said, I don't think that's any effect on his ability to pay. He has one outstanding case for which he has appointed counsel. There is a trial set already for February. To that end, I think he has expressed a sincere desire to pursue these charges. I think he has expressed an investment in his open cases. I don't think there's any risk of him not pursuing these cases to their conclusion. Yes, they are Act 3 eligible. Still, again, I don't think he has any demonstrated ability to pay. His address is 1819 Aberg. I think we all know it. So I would ask the court to order instead $500.
I'm sorry,
$500.
Very good. Any response from the state?
I would just highlight that while ability to pay is a factor the court is to consider at this stage in the proceedings, it is only one factor, is not the end-all be-all determinative factor in setting cash bail. I would ask the court to keep that in mind when making a decision. Thank you very much.
So I largely agree with the state, but I think $2,000 is an appropriate amount of cash. I'll also order the no contact with Troy P or Tanisha J, the ban from the 1100 block of Moorland Road, the conditions that you not use or possess any alcohol, and that you not use or possess any dangerous weapons. I'll enter not guilty pleas to the misdemeanors. The felonies, will the time limits for the pre-lid be kept?
They will.
Okay, we'll keep the time limits in place then, and we are adjourned. Thank you, sir.
Next up is Dane McCready.
This is the state of Wisconsin versus Delaney McCready, 25 CF 2968. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
Delaney McCready appears in person in custody and by attorney Connor Sheehan. She's received a copy of the complaint. The address on it is correct. I cannot say at this time whether she is eligible for representation through my office. And that will waive its reading. I apologize.
So you have the right to have an attorney represent you on a case like this. It's unclear. I believe you said it was unclear if Ms. McCready is eligible. Is that correct?
That's correct.
Okay, so you should apply as soon as possible because the public defender has a long wait list, and the longer you wait, the more people will jump ahead of you, okay? I find probable cause in the complaint. It's my understanding that there may be somebody who identifies as a victim who would like to make a statement. If so, can you please unmute and identify yourself? And you can use your initials, your first name and last initial. You'll have to unmute.
I'm her mom. I'm not a victim, but I was told to call and speak on her behalf.
Okay, well, she's got an attorney. So if you're not identifying as a victim, then I'll move along with the case. Thank you. What's the state's recommendation?
Thank you. The state is recommending a signature bond in this case. We're asking as bond conditions that the court order the defendant have no contact with child one, that the defendant be banned from the 4500 block of Barby, B-A-R-B-Y Lane in Madison, as well as the 600 block of Columbus Street in Sun Prairie, as well as Madison Street in Beaver Dam, and that the defendant.
Hold on. Banned from the 4500 block of Barbie Lane, and then
The 600 block of Columbus Street in Sun Prairie. And the entirety of Madison Street in Beaver Dam.
Okay, thank you.
And that the defendant not direct any physical discipline towards any child.
And do we have initials or something more specific for child victim one?
I believe the typical procedure is to identify individuals below a certain age just by how they appear in the complaint as child victim one or child victim two. So I'm not authorized to share any initials at this time, given those procedures.
Then I won't order that condition because there's no way the police can figure out if there's no way the police can figure out that that contact's being violated. Child one isn't specific enough. Attorney Sheen.
Thank you, Your Honor. One moment, please. Thank you. Just to clarify first, the condition that you're not ordering is to not direct any physical discipline?
No,
The no contact.
I'm hopeful the state will be able to give me some initials for child victim one. But without that, I don't think I can order the no contact with child one because it's not specific enough to any law enforcement agency. I haven't made a ruling on the no physical discipline to any child.
Thank you. So I'll start there then. I think that's overly broad to say the least. I would limit it to child victim one or two, if we're able to come up with any identifying factors that we're comfortable with. state that as a totality, I think is overly broad. The 4500 block of Barbie Lane is, I believe, the mother's address. It's not where, pardon me, it's not where Ms. McCready lives, no objection to that. The 600 block of Columbus Street in Sun Prairie is, I believe, an aunt's address. I don't see how that's relevant. I don't see how that isn't just a bit much. The entirety of Madison Street in Beaver Dam is too much. There's not even an address associated or a specific block. We object just because it doesn't seem appropriate. That's it, I believe. So just to restate, no objection to the 4500 block of Barbie Lane, and objection to the not direct any physical discipline towards all children. If it were amended to child victim 1 or 2, no, there would be an objection to that.
Okay. And response from the state.
So it's my understanding that the included addresses encompass areas where the child victim occasionally stays. I don't believe the child victim's parents are together, so I believe this came from the father. I think that is appropriate since the state is recommending a signature bond. These conditions are meant to protect the public while allowing the defendant the opportunity to remain in the community. Given that this is a felony offense, the state certainly could have asked for cash, so I don't think it's too unreasonable to ask for the recommended bans, nor is it unreasonable to ask for no physical discipline of any child, given the allegations here. I have not been authorized to provide any initials, so given the court's preference, or I'm sorry, I just received a message saying I am. My apologies for that confusion. The child's initials are T as in Todd, M as in Mary.
Right. So I will order a signature bond. The conditions that you have no contact with TM, that you're banned from the 4500 block of Barbie Lane. I'm not going to order the other no contacts, but if TM is at those addresses, you obviously can't be there, all right? I'm a little bit torn on the no physical discipline to any child, but reading the complaint, it kind of borders between, the way I read it, it kind of borders between physical discipline and kind of retaliation. I think on balance, though, the no physical discipline to any child is appropriate. So I will order that condition as well. This is a felony. There's a time limit for the prelims. Will they be kept or waived?
I'm going to waive the time limits just to make sure that she has time to procure counsel.
Very good. So we'll get those time limits for the prelim waived then. I believe that's all I can do for the parties today. So we are adjourned.
Next up is Donovan Benoit. Right, so agree.
I apologize. Who's up next?
Benoit.
One more time.
DENOI.
Thank you very much.
This is the state of Wisconsin versus Donovan Benoit, 25 CF 2976. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
Donovan Benoit appears in person in custody and by attorney Connor Sheehan. He has a copy of the complaint. We'll waive its reading. The address on it is correct, and I cannot say whether he's eligible for representation at this time. It hasn't been indicated.
Right. So you may be eligible to have the public defender represent you. You should reach out to them if that's how you'd like to be represented by an attorney as soon as possible, because they have a wait list. The longer you wait, the more people who will jump ahead of you. And you have the right to have an attorney represent you in a case like this. I find probable cause, and I'm sorry, did you say the address is good?
It is, thank you.
Okay. I find probable cause in the complaint. What are the state's recommendations?
The state is recommending a signature bond with the condition that the defendant have no contact with Brian F., and that he not operate any motor vehicle without a valid driver's license.
And is that Brian with a Y and I?
Sorry, it's, well, I guess I shouldn't say common spelling, BRIAN.
I'm sorry, no contact with Brian F. And
No operate any motor vehicle without a valid driver's license.
thank you.
One moment, please.
Very good.
Just to be clear, Your Honor, Brian F. is his next door neighbor and he lives in an apartment building. So I don't know how that could be accounted for or what the strictures are, what would be expected of Mr. Benoit if he were to walk out of his building or walk out of his unit rather and see Brian F. That would be my one concern.
All right. So the way I envision, no contact in situations like this, is you stick to your apartment. If you see, Mr. F walking down the hall, you can dip back into your apartment until he's gone. You should do that. If you're walking outside, don't look at him, don't stare at him. Just walk to wherever you're going and leave Mr. F to be. It's kind of how I see it. It's kind of like in a school. People pass each other in the hall. If you just don't do anything to them, don't look at them, don't stare at them, things like that. I would say that's not a violation of the condition. Does that make sense? Okay.
Thank you for clarifying. Then no objections.
Any response from the state?
No, I have nothing to add.
Okay, then I'll order a signature bond with the conditions that you have no contact with Brian F. and that you not operate a motor vehicle without a valid license. This is a felony and there are time limits for holding the preliminary hearing. Will those be kept or waived?
We're going to waive the time limits just to make sure that he has time to procure counsel.
Very good. Then we'll waive the time limits for the prelim and we are adjourned. Thank you.
Mr. Benoit, right this way. Next up is going to be Isaac Thomas.
This is the state of Wisconsin versus Isaac Thomas, 25 CF 2965. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
Isaac Thomas appears in person in custody and by attorney Connor Shan. He has a copy of the complaint. The address on it is correct. We'll waive its formal reading. At this time, I'm not sure whether he is eligible for representation through my office.
And Mr. Thomas, we have an address for you on Milwaukee Street. Is that still a good spot for you to receive your mail?
Yeah.
Okay. You have the right to have an attorney represent you on a case like this. Your eligibility is not determined, so you'll have to complete the evaluation process. You'd like to have somebody from the public defender represent you. So you should start that process as soon as possible because the longer you wait, the further down the wait list you'll fall. There's a pretty lengthy list, okay? Something else I thought. Oh, there is it looks like a DOC hold. I thought. There is. Okay. And there's a DOC hold. What are the states, I find probable cause of the complaint, what are the state's recommendations?
The state is recommending the court set cash bail in the amount of $10,000 with conditions that the defendant be prohibited from using or possessing any dangerous weapons as defined by the Wisconsin statutes, that he have no contact with any co-defendant, he have no contact with Momodu, MOMODU, last initial D as in David, or Abdu, ABDOU, last initial D as in David, and that he be placed on pretrial services for GPS monitoring if he's able to post cash bail. In support of this recommendation, I'll note that this, as I mentioned earlier, with the co-defendant is an extremely violent offense based on the allegations that are being set forth here. It's my understanding that the defendant was on supervision at the time this took place and was subject to GPS monitoring, and that monitoring apparently puts him at the scene at the time that a shooting took place. And when I say a shooting. That is still under investigation as far as whether there will be any additional charges filed, but I do know that someone died as a result of that. Again, that investigation is still pending, but this is outrageously dangerous behavior, and I think $10,000 is the minimum amount necessary to account for the exposure that the defendant is facing, as well as the Act 3 analysis.
And how do you say the second no contacts name? Abada.
It's ABDOU.
Okay.
I'm not certain if I'm pronouncing it right, to be fair.
That was closer than the name I had written down. All right, Attorney Sheehan.
Your Honor, I don't know what to say about the alleged shooting. We're talking about an armed robbery, and the co-defendant was given $5,000 cash bail. No objections to the no contacts or the GPS, as it's consistent with his other supervision, but he has serious ties to Dane County. He's been here for a very long time. He lives with his daughter who's here. His parents, his siblings, all of his friends live here. He's been unemployed for at least a few months. He's not going to be able to pay the $5,000, let alone $10,000. And if that amount is based off of an alleged shooting that we have no information about, I don't see how it's reasonable. So I'd ask that the bail be ordered at $5,000 to track with the co-defendant.
Okay. And response from the state?
Just note that the discrepancies are accounted for by the fact that, as is the case with most individual humans, the co-defendant's situation is not identical to Mr. Thomas's situation. The discrepancies in how they're situated as far as their personal circumstances, as well as their interactions with the criminal justice system in the past, are what justifies the discrepancies in the amounts recommended by the state.
All right. I disagree with the state. I think $10,000 is too low. I'm going to order $50,000 cash. We're in Act 3 territory. There's an alleged shooting here in which somebody was seriously wounded. They were shot in the stomach, and another person was shot in the head and died. $50,000 is about as low as I can go on something like that. I'm going to order that, Mr. Thomas, you do not use or possess any dangerous weapons, as that term is defined by statute. I'm going to order that you have no contact with any co-defendant. I'm going to order that you have no contact with Mamadou D or Abadou D. And I apologize. I assume I'm pronouncing those names wrong. I apologize for that. I'm not going to order the pretrial services. I don't like using pretrial services just to monitor where somebody's at. And it sounds like pretrial, the GPS monitoring was already being accomplished through a different agency on another case. Given the DLC hold, perhaps the bail amount is academic. These are felonies. Will the time limits for the preliminary hearing be kept or waived?
Kept, Your Honor.
Okay, we'll keep those time limits in place then, and we are adjourned. Thank you.
Next up is Ronald Duell.
And sorry, was that 1-5 or 5-0?
5-0.
Thank you.
This is the state of Wisconsin versus Ronald Duell, 25 CF 2521 and 25 CF 2961. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
Ronald Duell appears in person, in custody, and by attorney Connor Sheehan. He's received a copy of the complaint. The address, one moment, please. Do you want your mail to go to the beacon just in case? Where would you like it to go?
I'm up here, I'll be here.
Can we change the address to the Dane County Jail, please?
Yep.
Thank you.
And sir, if you're released, just make sure you get that address changed, so we're not sending your mail to the jail, okay?
Attorney Sheehan, it does look like the probation will just drop. If there was a signature bond in this case, the jail would not be the correct middle.
One moment, please.
Yeah, give me a moment. Yeah, we're gonna ask for cash.
And 115 Doty, please.
I can see if I can get a signature.
We're gonna find out. He is eligible for representation through my office. Actually, he already has counsel through my office for other cases. And we'll waive the other cases formal reading. That's all I have.
All right. So you have the right to have an attorney represent you in a case like this. You already have an attorney assigned. They should get that same person assigned to your new case, assuming there's no complications. I find probable cause in the new complaint. We're also here for a bail bond hearing on the older complaint. And the bail bond hearing is the violation was the new complaint. I'll take the state's position on each case, bail for each case.
Thank you. So in the older case, we're asking that the court set $500 cash with the prior conditions that were already in place. In 25 CF 2961, we're asking the court set an additional $500 cash with conditions that the defendant be prohibited from using or possessing any alcohol, that he be banned from merit or hospital unless necessary for obtaining legitimate medical care. In support of this recommendation, I do want to highlight that the defendant was given a signature bond back on December 22nd of this year following a pretrial services violation. The state did ask for cash at that point. The court decided to give him another chance. He was referred to pretrial services as a condition of that signature bond and unfortunately only made it one day before the offense date in the newer case where it's alleged that he battered a nurse who was simply tending to him. I think all of this justifies the amounts the state is asking for regardless of any ability to pay. I think that's outweighed by the sheer volume of cases in the violent act here as far as the 2961 case being an Act 3 eligible offense. So I would ask that you adopt the state's recommendations in full.
Attorney Sheehan?
One moment, please. Thank you. Your Honor, I've represented Mr. Duell before. He's not a violent man. He's a man with a drinking problem. He just represented to me that he doesn't even remember these allegations. There's talks of trespassing in the complaint. I don't believe this was ever a trespassing. He was brought to the hospital by Madison Fire and there he was being treated by PBJ in his professional capacity as a nurse. Bottom line is this is an alcohol issue. And while I can appreciate the state's request for cash bail, it is essentially academic. And I would ask the court to set it at $200 in each case, if not 500. Like 500 is simply too much.
All right, it looks like the DOC hold was dropped, and from what I can tell from the complaint, and I'm looking at the second paragraph under the facts heading, it says the complaint was originally coded as a trespass, but later turned into a battery. Then it describes Mr. Duell as a now discharged patient. So the way I read that is that he was originally there, he was discharged, and then I'm guessing he, according to allegations, refused to leave. So that's kind of how I read that.
I apologize if I may. The way PBJ describes it is that he is actually cleaning Mr. Duell's ear at the moment that Mr. Duell allegedly attempted to batter him. So I don't necessarily understand the charging document is how I would respond.
That's fair. Any response from the state?
I think what's being referred to in the complaint is probably the portion that's describing the nature of the initial call to dispatch. It was originally called in as a trespass and later turned into a battery. I don't really think that's here nor there. I think the meat of the allegations here is the allegation that the defendant battered this healthcare worker. And I would also point out that he did so while out on bail for battery to a healthcare worker in a different case. So I don't know that anyone else wants to hear more from the state because it's probably not favorable information.
Yeah, there's it's hard for me to not order cash when there's a condition in the older case not to drink. And then there's allegations that that condition's being violated. That to me necessitates some sort of escalation. So I think $500 in each case. I don't know if that's too steep or not. What I'll do is I'll bump it down a little bit to $400 in each case. In 25-21, I'll order the same conditions that were required previously. So pretrial services with alcohol monitoring. I'll order that you not consume or possess alcohol. And I'll order that you not be at any establishment whose primary purpose is the sale of alcohol. In 2961, I'll order, I believe I said $400. I'll order that you not consume or possess any alcohol. I'll order a ban from merit or hospital unless for any legitimate medical emergency, and I'll also order pretrial services in that case as well. I'll order that you're not to be released until you're able to be connected with pretrial services. I don't know if that'll be today or not, so it might be tomorrow when you're released. But I do believe.
Yeah, you've ordered cash, Your Honor.
Right, so if you post, you're not to be released until it's at a time when pretrial services is open. Okay. In regards to the new case, these are all felony charges. Will the time limits be kept or waived?
Waived, Your Honor.
Okay, we'll waive the time limits for having the preliminary hearing then. And with that, we are adjourned. Thank you.
Next up is Nathan Furtzinger.
This is the state of Wisconsin versus Nathan Furtzinger, 25 CF 2970. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
Nathan Persinger appears in person in custody and by attorney Connor Sheehan. He has a copy of the complaint. We'll waive its reading. The address on it is correct. He is eligible for representation through the Office of the State Public Defender. I do see a PO hold as well.
You have the right to have an attorney represent you on a case like this. You're eligible for a public defender. So they'll work on getting somebody assigned for you relatively quickly. I find probable cause in the complaint. What are the state's recommendations?
The state is willing to recommend a signature bond in this case. We're asking as a condition that the defendant be ordered not to use or possess any controlled substances or drug paraphernalia without a valid prescription for the former.
And I'm sorry, you said signature bond?
Yes.
Okay, Sheehan.
No objection to the signature bond. I would object to the condition of no use or possession of controlled substances or paraphernalia without a valid prescription, as it is already a law.
All right. Any response to the state?
I mean, I think that's sort of a moot point, as a lot of what we order here is the law. It's the law not to direct any acts or threats of violence towards anyone unless in self-defense, and that's a typical bond condition. So I just don't think that argument holds much weight. It's alleged the defendant was involved in a crash here that resulted in an arrest for OWI first, where there were alleged MDMA pills found in the driver's side door within his reach. I think that warrants a condition that is tailored to what the state's recommending.
Said OWI first. Oh, I see. Yep. All right. I'll order a signature bond. I'll also order the condition, Mr. Persinger, that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. While I understand that it's already the law, I think this helps reinforce the court's expectations of you. We're here for a second and subsequent offense. It's my hope that if you do struggle with this, that you'll work on getting some help now instead of later. I think by putting that as part of the bail conditions, that hopefully that keys into you that this is something the court's going to be looking at moving forward. All right. Regardless of how this case works out, this is an issue, like I said before, that you need help with. I'd encourage you to start work on that sooner rather than later. Okay. These are felony level charges. Will the time limits be kept or waived?
They will be waived, Your Honor, just to make sure he has counsel.
All right, so we'll waive the time limits for the preliminary hearing then. And with that, we are adjourned. Thank you. Wish you the best.
Next up is Willie Thomas.
This is the state of Wisconsin versus Willie Thomas. 25 CM 3065. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
Willie Thomas appears in person, in custody, and by attorney Connor Sheehan. He has a copy of the complaint. We'll waive its reading. The address on it is correct. And I do see a PO hold. That's all I have.
All right.
I apologize. He's already represented.
Okay, so you have the right to have an attorney representing in a case like this. They should get that same attorney from your other case assigned to this one, assuming there's no complications. I find probable cause in the complaint. What are the state's recommendations?
The state is asking the court to set $150 cash bail with the conditions that the defendant be banned from all Walgreens locations, all Dollar Tree locations, and have no contact with Gavin, Gavin, last initial J as in John. The reason for this recommendation is I truly believe it is the absolute minimum amount necessary without setting excessive cash bail to ensure the defendant's appearances. The defendant has several other pending cases in Dane County courts. He also has recent failures to appear. I'm seeing that a bench warrant was issued in case number 24 CM 566 back in June of 2024. As well as a bench warrant issued earlier that year in a different case that was issued in late April. There are some older bench warrants that were issued in late 2023. I do think all of this supports the state's recommendation, but again, that being said, it's really the minimum amount necessary. I don't think anything higher than that is warranted.
Attorney Sheehan?
One moment, please. Thank you. We would ask the court to order a signature bond. He does have other open cases. The last failure to appear was in June of 2024. There are other cases that have been opened and resolved since then. It's my understanding. Mr. Thomas was compliant when the officers showed up. I don't believe that, yes, the behavior is repetitive, but it's still, I don't believe that's serious. He hasn't been employed in many years. He is currently surviving on SSI. And there's a PO hold. So this still kind of amounts to a discussion of merits, not really a material effect. So I'd ask the court to order a signature bond.
All right. And any response from the state?
No, thank you.
All right. I'm going to order a signature bond in this case. I'm going to order that you're banned from all Walgreens, Dollar Tree locations, that you're to have no contact with Gavin J. It's going to be important that you comply with those conditions because failure to do so, as is the case in this case, could result in a charge of bail jumping, okay? Those are starting to stack up. So please do what you need to do. I will enter not guilty pleas on your behalf, and we are adjourned. Thank you so much.
Right, so that's, next up is Joseph Green. Great, sounds like.
This is the state of Wisconsin versus Joseph Green, 25 CM 3059. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
Joseph Green appears in person, in custody, and by attorney Connor Sheehan. Mr. Green has a copy of the complaint. We'll waive its reading. The address on it is correct, and he is eligible for representation through the Office of the State Public Defender.
Looks like there's a DOC hold as well.
There is.
You have the right to have an attorney represent you in a case like this. You're eligible for a public defender, so they'll work on getting somebody appointed to your case, all right? I find probable cause in the complaint. What are the state's recommendations?
Sorry, just one moment. The state is going to recommend a signature bond. It's my understanding that the department is initiating revocation proceedings, so that forms most of the basis for that recommendation. I do think this is a close call, given the defendant's criminal history and resistive behavior. But also, this is a more minimal offense as far as the other allegations that have been in front of the court today. So we're willing to give him a signature bond if for any reason that hold gets dropped. We'll ask that he have no contact with the victim whose initials are GKG, and that he be banned from Rocky's Liquor Store located on the West Beltline Highway in Madison.
No objections.
And I'll order a signature bond with the conditions that you have no contact with GKG, that you're banned from Rocky's Liquor in Madison. I will enter not guilty pleas on your behalf, and we are adjourned.
I'm sorry, Commissioner, is that just the single Rockies location on the West Beltline or all Rockies?
Oh, I'm sorry, it was just the location as requested by the state on the West Beltline, excuse me. Thank you.
Next up is Taylor Ayers. I like your approach.
Thank you. I like your hair as well. Yeah. This is the state of Wisconsin versus Taylor Ayers, 25 CF 2959. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
Taylor Ayers appears in person in custody and by attorney Connor Shan. He has a copy of the complaint. We'll waive its reading. The address on it is correct, and he is eligible for representation through the Office of the State Public Defender.
You have the right to have an attorney represent you in a case like this. You're eligible for public defender representation. So they'll work on getting somebody appointed for you. Hopefully that's that process doesn't take too long, okay? I find probable cause in the complaint. What are the state's recommendations?
Thank you. The state is asking that the court set $500 cash bail with conditions that the defendant not operate any motor vehicle, that he refrain from using or possessing any controlled substances or drug paraphernalia without a valid prescription, and that he be placed on pretrial services for random UAs to monitor any substance use. The allegations here involve observations of very bad and almost downright dangerous driving with signs of impairment, as well as allegations of cocaine found in the defendant's sock. He has been convicted of both OWI-related offenses and possession of cocaine several years ago. With this level of OWI, if convicted, he is facing presumptive prison. So the state believes on balance that cash is appropriate to ensure future appearances at all of his court proceedings going forward. I would also note that he should not be driving whatsoever, given that he's subject to a lifetime license revocation as it stands. So we would ask that the court set a simple no driving condition whatsoever, rather than no operating without a valid license, as it seems unlikely he will ever possess a valid license at this point.
Thank you. Appreciate the state's points. Regardless, if this is charged with a 5 or 6, it also means that he has been charged with a 4 in the past, which also, included jail time. Showed up to that. That case was resolved. I heard no talk of missed court dates, which I assumed would have come up. Mr. Ayers is willing to post cash. He would be happily post $250.
All right. And any response from the state?
Well, the purpose of cash bail isn't necessarily to land on an amount that someone is happy with. I can understand that someone wouldn't be satisfied with the amount being recommended or even set by the court, but I do think that this balances all the appropriate factors as outlined in the bail statute here, and that 500 is the minimum necessary to ensure his future appearance.
So there's a couple things at play. Now, Mr. Ayers has attended court in the past. But there's escalated exposure from a charge like this. There's also the consideration of when the priors were. The first was in 1999, the second was in 2001. And then there's about 21 years without an offense. Or 20 years without an offense. The third, the incident date is 2020. And then the fourth, the incident date is 2023. That's concerning. It's concerning that not only was Mr. Ayers driving when he's not licensed to, but the allegations are that he was driving recklessly all over the road, went across the intersection, and almost hit other vehicles. I think 500 is too low. I'm going to order $1,000 cash. That Mr. Ayers not operate a motor vehicle, that he not consume or possess any drug paraphernalia, that he not consume or possess any controlled substances or drug paraphernalia without a valid prescription. And I'll order that he report to pretrial services by 10 o'clock of the next business day for drug monitoring after his release. And to set that all mixed up. I'll order that you report to pretrial services by 10 o'clock of the next business day after your release for drug monitoring. I'll enter not guilty pleas to the misdemeanor and the forfeiture. In regards to the time limits for counts 1 and 2.
One moment, please. We'll waive the time limits just to ensure he has time to get counsel.
Very good. Then we'll waive the time limits for having the preliminary hearing done, and we are adjourned.
Thank you.
Next up is Terrence Baker.
This is the state of Wisconsin versus Terrence Baker, 25 CF 2967. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
Terrence Baker appears in person in custody and by attorney Connor Sheehan. He's received a copy of the complaint. We'll waive its reading. I do have an updated address to provide the court.
Very good.
So it's still on Vernon Avenue in Madison, same zip code, but it's 802 Vernon Avenue, apartment number 4. And he is eligible for representation through the Office of the State Public Defender.
All right. So you have the right to have an attorney represent you in a case like this. You're eligible for the public defender. They'll work on getting somebody appointed to your case as soon as possible. All right. I find probable cause in the complaint. What are the state's recommendations?
Well, notwithstanding the co-defendant Thomas's cash bail amount, just for consistency's sake, I'll go with the notes I have here. We're asking for Mr. Baker that the court set $10,000 cash bail with conditions that he be prohibited from using or possessing any dangerous weapons, that he have no contact with Momadou, last initial D, or Abdu, last initial D. We have no contact with any co-defendant, and that he be placed on pretrial services with GPS monitoring if able to post. It's my understanding that the defendant was on supervision out of the state of Illinois at the time that this took place, as well as out on bail. He has had a number of arrests and bench warrants issued in response to his conduct in the last 5 years. That's on top of the fact that this is an Act 3 eligible offense, that it was extremely dangerous. And as mentioned earlier, although investigations are still ongoing, it didn't result in the loss of someone's life with the shooting aspect of the conduct that took place. So the state's belief is that $10,000 in Mr. Baker's specific circumstances is the absolute minimum amount necessary. If the court sees fit to set something higher to be more consistent with co-defendant Thomas's amount, the state would also certainly be open to that.
And Attorney Sheehan?
One moment, please. Thank you. No objection to the non-monetary conditions. We would ask for $5,000 cash bail to be consistent with the first co-defendant, purely on a basis of ability to pay and the fact that he is facing extradition to Illinois, just to facilitate that. Thank you.
Thank you. I do believe $50,000 cash here is appropriate. There's alleged to have been guns involved. Somebody was shot in the stomach and another person lost their life. I understand investigations are still ongoing regarding that. There's also these extradition pieces which indicate that Mr. Baker may be committing crimes in other states, which is obviously very concerning, gives him an incentive to flee, and shows he has some ability to get to other states. In addition to the cash, the $50,000 cash, I'm going to order that you not use or possess any dangerous weapons, as that term is defined by statute, that you have no contact with Mamadou D or Abadou D. I'm not going to order the pretrial services. These are felony charges. Will the time limits for the preliminary hearing be kept or waived?
Waived, just to make sure he has counsel.
All right.
It's for sure no contact.
Yes, and no contact with the co-defendants. Thank you. So we'll waive those time limits and we are adjourned.
Okay, quick. Next up is Jesse Riojas.
This is the state of Wisconsin versus Jesse Riojas, 25 CM 3067. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
Jesse Riojas appears in person in custody and by attorney Connor Sheehan. He's received a copy of the complaint. The address on it is correct, and he is eligible for representation through the state public defender. I apologize. We'll waive its formal reading.
So you have the right to have an attorney represent you on a case like this. You're eligible for a public defender. They'll work on getting somebody appointed for you shortly. Sometimes that is a quick process. Sometimes it can take a little bit of time. So just hang in there. I find probable cause in the complaint. What are the state's recommendations?
The state is willing to recommend a signature bond despite the described resistive or obstructive behavior that's outlined in the complaint. We would ask that the defendant be prohibited from using or possessing any alcohol during the pendency of this case and that he be banned from Whiskey Jack Saloon located on State Street.
One moment, please.
Very good.
Would object to the ban from the physical location of Whiskey Jack. It's my understanding that the argument happened outside of it, not actually within it, and that there were no staff or patrons involved. As such, we'd object.
Okay. Any response from the state?
I don't think Whiskey Jack's wants him there, so I would ask that he be banned.
Do you have any information from Whiskey Jack's about a trespass or anything like that?
I don't, but it's my understanding that he was perhaps either, well, I'll put it this way, that he was overserved inside Whiskey Jack's and that the buildup to the argumentative behavior initiated within Whiskey Jack's. I really don't think it's anywhere near unreasonable to ban him from Whiskey Jack's. It doesn't appear that he works there or has any other connection to that establishment. And frankly, if they were to trespass him, that he would likely receive a citation, and that wouldn't be any mark of a deterrence as much as a bail condition would be in terms of enforcement. So I would ask that you please ban him.
Your Honor, if I may.
Yep.
They're allowed to ban him as an establishment. They're allowed to do whatever they please, but a bail condition is usually related to the charge. And I don't see how that's necessarily related. We would debate the characterization of as being overserved. Again, the establishment can do whatever it wants, but he doesn't have to justify why he doesn't deserve a bond condition. They have to justify why he does.
I agree with Mr. Riojas. I think there are plenty of other places he can go if he'd like to meet friends, although I will order the no alcohol condition, so I'd encourage you to do what you need to do to make sure you're complying with that condition as well. Probably not a good idea for you to be at a bar if you're ordered not to drink any alcohol. But ultimately, I'll leave that up to you, and if we're back here due to a violation, it's very possible, very likely that you could be ordered to post some cash before being released, all right? So I'll order a signature bond. I'll order the condition that you're not use or possess any alcohol. I'll enter not guilty pleas on your behalf. And with that, we are adjourned. Thank you.
Right this way.
So, thank you.
Next up is Shakir Williams.
This is the state of Wisconsin versus Shakur Williams, 25 CM 3043 and 25 CM 3066. Can I have appearances, please?
88 Cecilia DeMarco for the state.
Shakur Williams appears in person in custody.
I'm not Shakur Williams. I'm Floyd Williams.
I have been brought the wrong defendant.
Okay. Yep, there's a Floyd Williams. Thank you for that clarification.
Okay, that's. You go for that.
Thank you.
You already going, you want to switch complaints.
All right. This is the state of Wisconsin versus Floyd Williams, 25 CF 2955 and 25 CF 2958. Can I have appearances, please?
88 Cecilia DeMarco for the state.
Floyd Williams appears in person in custody and by attorney Connor Sheehan. He has received a copy of both complaints. The address is correct, 1819 Aberg. We'll waive their formal reading and he is eligible for representation through my office.
I'm sorry, you said it's 1819 Aberg.
That's what I have on. Oh yeah, I apologize. That's what I have on my paperwork, not on the complaints. So 1819 Aberg, please.
I had a house fire. I just recently had a house fire. Yeah, that's right.
Right. I'm sorry, did he say Mr. Williams is eligible for?
Yes.
Okay, so you have the right to have an attorney represent you on a case like this. You're eligible for a public defender. They'll work on getting somebody appointed to your case as soon as possible, all right? I'm just reading the complaints quick. Find probable cause in the complaints. What are the state's recommendations?
The state is willing to recommend signature bonds in each of these matters as conditions, beginning with case number 25 CF 2955. We'll ask the court set a condition that the defendant not use or possess any controlled substances or drug paraphernalia without a valid prescription. In the second case, which is 25 CF 2958, I believe it is, we would ask that the defendant be banned from all Fleet Farm locations.
One moment. No objections.
All right. So in 25 CF 2955, I'll order a signature bond with the condition that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. And in 2958, I'll order a signature bond with the condition that you are banned from all Fleet Farms. And these are felony charges. So will the time limits for the preliminary hearing be kept or waived?
One moment. Waived, please.
Okay, we'll waive the time limits for the preliminary hearing. And we are adjourned. Thank you.
Right this way. Next up, we'll have Mr. Shakur with us. All right, let's try this. Evan Wolfman.
This is the state of Wisconsin versus Avi Wolfgram, 25 CF 2966. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
Avi Wolfram appears in person in custody and by attorney Connor Sheehan. He has received a copy of the complaint. We'll waive its formal reading. The address of 303 Hudson is correct. And he currently is represented by a private attorney in another matter. So I assume that he'll represent him in this one as well.
Right. So you have the right to have an attorney represent you in a case like this. We'll give you instructions for contacting the public defender in case you need it. It sounds like you have a private attorney. You'll have to work out with that person how to get representation on the newest case. Each time you pick up a new case, that attorney has to opt into representing you on that new case, okay? Something falls through, you'll have the public defender's number, all right?
Sure, thank you, and
I wanna, yep,
I was gonna ask, so.
well, I just wanna let you know.
Oh, yeah, my question is,
Okay, that's all. Thank you.
Um. I find probable cause in the complaint. What are the state's recommendations?
Thank you. The state is asking that the court set $500 cash bail with conditions that the defendant have no contact with the person whose initials are VAZ-S, that he be banned from the 500 block of North Street, and that he be banned from the 2300 block of Summers Avenue, SOMMERS, both in Madison. Those mirror the bond conditions that are already set in 25 CF 2001. And unfortunately, we are here with allegations that the defendant is very specifically violating those bond conditions. And the open case that I mentioned is relevant. That is a stalking case. The victim is VAZ-S. It's alleged here that despite being out on signature bond, he engaged in 2 deliberate violations of said bond conditions. The logical nexus here is that an increase in cash bail is necessary given the deliberate disobeying of the court orders that were previously set as a condition of his signature bond.
One moment.
Yep.
No objections, Your Honor.
Okay. And I think that's, the recommendation was appropriate. So I'll order $500 cash with the conditions that you have no contact with VAS, that you're banned from the 500 block of North Street, and that you're also banned from the 2300 block of Summers Avenue. These are felony charges, so you have the right to have a preliminary hearing within a certain amount of time. The time limits be kept or waived?
They'll be waived. I want to leave it to the discretion of the attorney.
Okay, so we'll waive the time limits for having the preliminary hearing then, and we are adjourned. Thank you. Good luck.
Next up is Julian Patton.
This is the state of Wisconsin versus Julian Patton, 25 CF 2963. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
Julian Patton appears in person and in custody alongside attorney Connor Sheehan. He has received a copy of the complaint, will waive its reading. I do need to give an updated address though, whenever you're ready. It is 634 Woodside, spelled as it sounds, Avenue in Ripon, Wisconsin. I don't have a zip code written down here. Do you know it? 54791. So that's a current address. And I don't know whether he's eligible for representation through the Office of the State Public Defender at this point.
So, if you'd like to be represented by the public defender, you should reach out to them as soon as possible. That sheet of paper has instructions on how to contact them. They do have a wait list, so you'll want to apply as soon as you can or get evaluated as soon as you can. Because, well, if you're not applying or you're taking your time, other people are going to apply and potentially jump ahead of you, okay? So I assume you want to keep your case going, so make sure you get that application in or that evaluation done as soon as possible. I find probable cause in the complaint. What are the state's recommendations?
The state is willing to recommend a signature bond in this case. We would ask that the defendant be ordered not to possess or consume any alcohol while the case is pending, and that he not operate any motor vehicle without a valid driver's license to do so.
No objections, Your Honor.
Okay. This is a little bit of a light touch, okay? Most people don't get this recommendation. So there's allegations here of substance abuse. If that's a problem for you, make sure you get it worked on sooner rather than later, okay? You know, it's not something that has to be ordered for you to start working on, all right? I don't want to see you back here with violations of this condition. One of these charges is a felony, which means if you violate the conditions that I order, the state could charge you with felony bail jumping. And those charges multiply exponentially, okay? I'll take a chance on you. I'll order the signature bond. I'll order that you not use or possess any alcohol and that you not operate a motor vehicle without a valid license. Additionally, violations of bond could see that motor vehicle condition change to just you're not allowed to drive. That can be quite onerous. So now's your chance to show us you can comply with this, do what you need to do, and live the life you're capable of, okay?
Absolutely.
All right, any questions for me? Okay. Then I'll enter not guilty pleas to counts 2 and 3. Count 1 is a felony.
We'll waive the time limits.
Okay, we'll waive the time limits for having that preliminary hearing done, and we are adjourned. Thank you. Bless you.
Next up is Shakur Williams.
Is this your address?
This is the state of Wisconsin versus Shakur Williams, 25 CM 3066 and 25 CM 3043. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
Shakur Williams appears in person, in custody, and by attorney Connor Sheehan. He's received copies of the complaints. Will waive their formal reading. The address of 1132 Gammon is correct, and he is eligible for representation through the Office of the State Public Defender, but I see that he already has appointed counsel.
Okay, so you have the right to have an attorney represent you in a case like this. Public defender will work to get that attorney on your other case assigned to this one, assuming no complications. That should happen in a quick order, assuming the holidays don't obstruct that. I find probable cause in the complaints. What are the state's recommendations?
We're willing to recommend signature bonds in each of these matters. In case ending in 3066, we would ask that the defendant be prohibited from using or possessing any alcohol during the pendency of the case. In case ending in 3043, we would ask that the defendant be banned from any Woodman's location.
No objections, Your Honor.
Then in 25 CM 3043, I'll order a signature bond and the condition that you're banned from Woodman stores. And 25 CM 3066, I'll also order a signature bond with the condition that you're not consumer possess any alcohol. I will enter not guilty pleas on your behalf, and we are adjourned. Thank you.
Right, this way, sir. Next up is Michael Loveless for bail bonds.
This is the group file of bail hearing for Michael Loveless, 25 GF 37082. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
Michael Loveless appears in person in custody and by attorney Connor Sheehan. The address of 205 South Bird Street, number 2, if that's what you have on file, is correct. He is eligible for representation through the Office of the State Public Defender.
So if this case gets charged out, you'll have to write to have an attorney represent you. Looks like you're eligible for a public defender, but that'll all depend on whether this case gets charged out or not, okay? What are the state's recommendations?
The state will be recommending a signature bond. We would ask for an order and date in approximately 30 days. As conditions, we will ask that the defendant have no contact with child victim 1, whose initials are TSB. Or I'm sorry, whose initials are TJMT. And that he have no contact with her mother. First name TASIA, last initial B as in boy. And have no contact or no unsupervised contact with anyone under the age of 18.
One moment, please.
Yep.
So. There are no objections, Your Honor.
All right. Then I'll order a signature bond with the conditions that you have no contact with RTJMT or TASIA B, and that you have no unsupervised contact with anyone under the age of 18 years old. We'll get a date for that ordering.
I'm sorry.
Before that, I just want to clarify what the no contact initials were.
Yeah.
I had heard a couple of different sets of jumbles.
Yes, so what I have would be TJMT.
TJMT.
Yes.
And
And
then
then Taja B is just the two individuals,
So Taja B is one person.
and TJM is a single person.
Yes, that would be her daughter.
So if you're just asking.
Yes.
Right now, we're meeting at February 2nd, 8:30 for.
Sounds good.
so we'll get that set then. Keep an eye on your mail. Because if there's a charging document, it might be sent to you. All right, and with that, we are adjourned. Thank you.
And I could just have a few moments in between. The battery on my computer has just died, so it needs a moment to get started up again.
Sure.
Good luck.
Great stuff.
Chris?
This is the state of Wisconsin versus Philip Cribbs, 25 CF 2810, 25 CF 2811, and 25 CM 3062. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
Philip Cribbs appears in person in custody and by attorney Connor Sheehan.
Yes.
1819 Aberg is correct. We have a copy of the complaint. We'll waive its formal reading, and he is currently represented through the Office of the State Public Defender.
Okay. So you have the right to have an attorney represent you on a case like this. They should get somebody appointed to your newest case as soon as they can. We're here for a bail bond hearing in 25 CF 2810 and 25 CF 2811, and a new complaint on 25 CM 3062. Attorney Sheehan?
Yes, I would like to move to dismiss 25 CM 3062.
Lack of probable cause?
Yes, Your Honor.
All right.
I don't believe that there's evidence, pardon me, I don't believe that they've alleged facts sufficient to demonstrate that he knew he was violating a domestic abuse order. In the complaint, pardon me, it specifically says that Mr. Cribbs called 911 and told the police that he sent someone to get the check and that JAB had rudely told them to leave. I don't think that demonstrates knowingly violating the terms of the injunction. In the injunction, it says it has to go through a law enforcement or a lawyer. It sounds like he got confused. It sounds like he was very upset. It sounds like he didn't know the terms. I don't know how many times, I don't know how common it is for someone to call the police and say, this is what I did, indignant that it was not fulfilled. I just don't think that there is anything to demonstrate that he knew what he was doing was a violation.
And any response from the state at this time? Do you need a little more time to?
No, I just don't. I know that he said he didn't know, but I don't think there's a basis to believe that. I mean, essentially what we have here is the third party basically selling him out. There's a statement on page 3 stating that, paragraph 2, SJB stated that she did not know anything about the restraining order, but she knew that a judge ordered a third party to go over to the apartment, and the defendant stated that it could not be him, but did not say who specifically the third party was. She stated that it was anyone but him. Third paragraph, SJB confirmed that the defendant specifically asked her to go over to the Randolph Drive address, providing her the exact address and apartment number in order to contact JAB. She stated that the defendant asked her to go over there to obtain a check and bring it back to him. The defendant also provided SJB with JAB's phone number. She was told not to wait for police before contacting JAB. I understand the defendant says that he didn't know the terms of the restraining order, but it's my understanding he was served with it. So that's just really not good enough at this point. He knows that this woman wants absolutely nothing to do with him. I understand it's inconvenient to have to wait for the police. It seems like they did not respond in a timely manner, but regardless, he was not supposed to have anyone else contact the victim on his behalf other than law enforcement. He did exactly that. That is outlined in the complaint in detail. I don't think there's a basis for this to be dismissed.
And I'll give you the final word, Attorney Sheehan.
I appreciate that, but it's within the four corners of the complaint. Anything that he has said, it's consistent with what this third party said. It could be read as ratting him out. It could also be read as consistency across the board. So I just don't think that there is, within the four corners of the complaint, evidence of him knowingly violating the terms.
All right. I pulled up the criminal jury instruction 2040 to assist me. Specifically, I think the element at issue is element 3, that the defendant, Mr. Cribbs, knew that the injunction had been issued and knew that his acts violated its terms. That points to footnote 5. That explains the knowing and intentionally violates wording. The first paragraph on page 4 of those jury instructions, that's the second paragraph in footnote 5, discusses proper service of the injunction. looks like the injunction was served on Mr. Cribbs. So there's certainly an argument here for trial, but for a probable cause determination, all reasonable inferences go in favor of the state. It's a reasonable inference that Mr. Cribbs knew that he wasn't supposed to have contact through a third party, independent third party, not the police. That was a clear violation of the injunction. So I'll dismiss the motion to dismiss for lack of probable cause. I think it raises a trial issue. In regards to the bail conditions, assuming I didn't miss anything else, I'll take the state's position.
Thank you. So the state is asking the court to set $1,000 cash bail in the new case 25 CM 3062, given that it is now the fourth open case that the defendant has pending with the same victim. And that's outside of the fact that the injunction is also in place. He just had cash bail reduced to a signature bond just days before this took place. I would ask that he also be ordered to have no contact with, I believe it's pronounced Jodeci, Jodeci, last initial B as in boy. In regards to the bail hearings on the other two open cases, I would ask that the court reinstate bail at the amounts that was originally set that was recently reduced. So in 2810, that the court set cash bail back at $1,000 with the defendant having to post whatever the difference is between the recent reduction and $1,000, and that the court set cash bail back at $500, which was the original amount set in 2811, with the defendant also being expected to post the difference.
Attorney Sheehan.
One moment, please. Thank you, Your Honor. So I just want to clarify, do we know what the difference is, or is it just we're acting under the assumption that it's a $2,500 collectively bail?
So it looks like $300 was posted. It was set as high as $1,000. So I think the state's asking for $1,000, but $300 was posted, so it'd be an outstanding amount of $700.
Okay. And that's in 2810. Okay.
Similarly, it would come out to $200 on 2811.
Okay. So it comes out to $1,900 were he to secure his release. So the alleged conduct is that he called the police 9 times in order to get his check on December 23rd, I believe, and on time for Christmas. The man's indigent. The address listed is 1819 Aberg. It sounded like he got confused, or he was very upset. He engaged in some kind of self-help, which he shouldn't have. But I don't think that merits $1,900 cash bail is what we're essentially looking at. The non-monetary conditions, there's no grounds for objection. I do not object, but I just don't think that amount is necessary. I think it's too much.
And I'll give the state the final word.
Thank you. So I think the victim's statement that was read at the bail hearing in the 2810 and 2811 cases on December 22nd is pretty poignant. The quote that I have here includes the words, "To give this man a lesser bail and or a signature bond would be a doorway to him reoffending at the expense of my kids and I." That's exactly what happened. I understand that he needed the money. I understand that it's before the holidays, but he was served with the restraining order. And this does not indicate simply someone who is desperate for money. This indicates someone who is desperate for attention. He has been victimizing this woman for years. He has multiple domestic violence cases involving her as the victim. There are allegations in some of them that he was threatening to harm her and her children. He was using this to have contact with her. He's going to characterize it differently, and I understand that. He has the right to a trial. He has the right to dispute the state's characterization. But the way that I see this is not as simple as the defense would like it to seem, and I do think that that warrants an increase in cash bail. He was given a chance at a decreased cash bail amounts, which he was able to post, And instead of using that as an opportunity to conform his behavior to the law while out in the community, he did the exact opposite. He knew that he had to use only the police for a preserve the peace to retrieve any belongings at the victim's residence. He was served with the restraining order that had those terms. He does not get to dictate that the restraining order only applies on certain occasions when it's convenient for him to do so. That completely defeats the purpose of a court order. And I think that the fact that he was willing to do so indicates that an increase in cash bail in the amount the state has asked for across these three matters is absolutely warranted.
Thank you. So I feel a little bit stuck between Scylla and Charybdis. You know, I can certainly appreciate, Mr. Cribbs, the situation you were in where, there's this check that you believe, JAB has. You're calling the police to try to get it back, and then it seems like when you're not getting it back, it escalates to a third-party contact to try to get that check back. I think there are some mitigating factors there, that lead me to disagree with the state. However, there's also this long history of contact too, right? And that doesn't just get flushed down the drain because you're kind of doing the right thing in the wrong way, if that makes sense. So I do believe there needs to be cash in the new case. I'm going to order $250 cash in 3062, and that you have no contact with, and I apologize for mispronouncing the name, but JOSUE B. In 2810, I'm going to order $300 cash that's already been posted, so no new cash will have to be posted. And I'm going to order pretrial services in each case. In 2810, I'll order pretrial services with GPS monitoring. I'll order no contact with JOSUE B and a ban from the Greenbrier apartment complex. In 2811, I'm going to order $300 cash, pretrial services for GPS monitoring, and the ban from the 200 block of Randolph Drive in Madison. And 3062, the condition I forgot is pretrial services with GPS monitoring. And no, there's no, let's see. I'll also order a ban from the 200 block of Randolph Drive in that case as well. In regards to the pretrial services, I'll order that you're only to be released at a time when you can be fitted with, do you have the electronic monitor?
Yes, sir.
Okay. I'll order that you're to report to pretrial services by 10 a.m. of the next business day after your release. Please make sure you're making that condition, because if you don't, we'll be right back here. It's likely the state's gonna get what they asked for, okay? You really need to make sure you're being respectful of this no contact. It means no contact. If the police can't come to you right away to assist you, you're gonna just have to wait, all right? And that's just the way things are gonna have to be. I understand it's your money. People don't like the money being played with. but that's just how you're gonna have to manage this moving forward, okay? I'm giving you a real light touch because I could see you were trying to do the right thing, but you can't be so insistent. You gotta just relax, okay? All right? I think you can do that. That's going to be my expectation, and the expectation of this court moving forward, okay?
Yes, sir.
I'll enter not guilty pleas or a not guilty plea in 3062. The other felony level cases have prelim set on January 22nd at 1:30. So please make sure you're showing up for court and abiding by the conditions I've ordered today, all right? All right. I believe that's all I can do for the parties today, so we are adjourned.
Next up is Tremaine versus.
This is the state of Wisconsin versus Tremaine Pursley, 25 CF 2964. Do you need me to slow down or you could? Yeah. Can I have appearances, please?
ADA Cecilia DeMarco for the state.
Tremaine Pursley appears in person in custody and by attorney Connor Sheehan. He's received a copy of the complaint. We'll waive its formal reading. I do need to make a minor correction to the address. It's apartment 3, not apartment 2 at 1810 Brittany. And I'm not sure at this time whether he's eligible for representation through my office.
So you have the right to have an attorney represent you on a case like this. Your eligibility for a public defender hasn't been determined. So if you'd like to have a public defender represent you, you should reach out and complete that evaluation as soon as possible, okay? There's a wait list, so the longer you wait, the more people will jump ahead of you, especially with the holidays. So make sure you get that done as soon as possible so your case isn't delayed, okay? I find probable cause of the complaint. What are the state's recommendations?
The state is recommending $500 cash bail in this case. We're asking as conditions that the defendant be ordered to have no contact with officers Dish, DISCH, Moldenhauer, MOLDENHAUER, and Hayes, unless in their official capacity as law enforcement officers. No contact with Devontae, DEVONTA, last initial G as in girl. No contact with Herman, HERMAN, also last initial G as in girl. Banned from the 1900 block of Brittany, BRITTANY Place in Madison, and no use or possession of any alcohol. I do think some of this behavior is alcohol fueled, but it is violent behavior nonetheless. Counts 1 and 2 are Act 3 eligible, which is factored into the state's argument here. The case does contain allegations of threats to come back and assault or kill or greatly maim both the victims and law enforcement officers. It's my understanding the defendant has been convicted of some violent offenses in the past as well. I think some cash bail is likely needed. I don't think it needs to be any more than what we're requesting here today, but on balance, this is not behavior that is indicative of someone who's going to follow court orders willfully and without some amount of cash on the line to incentivize compliance with court orders such as making all future court dates and following bond conditions.
One moment, please.
Ready. So I just want to confirm the conditions. I have no contact with officers Dish, Moldenhauer, and Hayes, except as in their position as law enforcement officers. No contact with Devonta G or Herman G, a banned from the 1900 block of Brittany Place in Madison, and that Mr. Pursley not consume or possess any alcohol. Is that correct?
Yes.
Okay.
Yeah.
Thank you. No objections to any of the non-monetary conditions. $500 is reasonable. It just is. It's generous, if anything, but the bottom line is Mr. Persley can't afford it, and I have to ask for a reduction to 250 on his behalf. It is not an unreasonable amount of money. I just simply have to ask for less, because if not, then he won't get out of custody.
Thank you. Response from the state?
I'll leave it up to the court to decide.
I think what I hear, everybody agrees that $500 is a reasonable amount, but the issue is Mr. Persley's ability to pay. There's some quite vicious threats made to civilians, to police officers. You know, there's the resisting charge. Attorney Sheehan, if you give me something more to make me feel more comfortable ordering a signature bond, I'm not
Sure.
adverse to it. But I think I would need something more, some sort of
I'd be happy to. He's a stay-at-home dad for his 4-year-old child. His partner works. He's been a Dane County resident for 30 years. The allegations are, I would agree, alcohol fueled. And I think that there are other means of addressing that without keeping him in custody, and his actions are his responsibility, but the imposition of more cash than that would effectively punish the rest of his family, which is, again, his responsibility. But I would ask the court to keep it in mind.
and if the state has a final word, I'll hear from the state.
Sure, and I can appreciate defense counsel's argument. I don't think anything you said is unreasonable, but I do have to push back by virtue of the violent allegations here in the form of the specific threats and the allegations of, you know, breaking the door, the window with the brick, as was alleged by one of the victims. So when I said the defendant has prior violent convictions, he was convicted of strangulation and suffocation as an act of domestic abuse, specifically back in early January of 2016. He was ordered to complete AODA and drug treatment as recommended while he was incarcerated. I don't know exactly how feasible that was given the length of his sentence, but nonetheless, the fact that he does have prior violent convictions, domestic abuse related, nonetheless, I don't think bodes well in favor of allowing him to be released on a signature bond when there's more violence that's being alleged here when he's under the influence of various substances.
I would just like to add, I believe that was his last conviction.
And that reflects what I was able to see in our system, that there were older convictions, kind of a gap before we got here. I mean, you have a 4-year-old child. If somebody said some of these things to your kid, you wouldn't be very happy, I assume, right?
Yes, it was all this alcohol.
Well, these are somebody else's kids.
I know.
They're people doing their jobs.
I had no clue.
Allegedly, you know, these are just allegations, but they're trying to live their lives too.
Sure.
So what I'll do is this. I'll order a signature bond. I'll have the conditions that you have no contact with officers Dish, Moldenhauer, and Hayes, except in their capacity as law enforcement officers. I'll order that you have no contact with Devonta G. or Herman G., that you're banned from the 1900 block of Brittany Place in Madison. I'll order that you're not to consume or possess any alcohol. I'll order that you're to make no acts or threats of violence to anyone. Also going to order pretrial services for alcohol monitoring. That's an onerous condition. If you're not complying with it, we'll be right back here, and the state will likely get its request for bail money to be imposed granted. Please comply with these conditions. These are felony charges, so violations of these conditions could result in a felony charge for bail jumping, and those stack up real fast. and your exposure stacks up real fast. Okay, it's holiday season. You want to be with your kids. I get that. That's where you should be. Please don't make this an easy decision for somebody sitting here by saying, well, you had your chance and you blew it. Okay, this is gonna be up to you on whether you stay in or out. Okay, and I don't need to hear from you. These hearings are recorded. Anything you say could be used against you. I'm gonna take the chance on you, but please don't make me look stupid by blowing it. Okay,
Thank you so much.
because the threats made here, they're allegedly made, but they disgust me.
Yes, sir.
All right.
Yes, sir.
So I'll show you some grace and hopefully you can show some other people some grace in return, all right? All right. I'll enter not guilty pleas to the misdemeanors. The felonies, will the time limits be kept or waived?
Waived, please.
Okay. We'll waive the time limits for having the preliminary hearing then, and we are adjourned.
Thank you.
This is your chance, sir.
Everyone's dead.